Good evening and welcome to Newshour Agenda. Madhavdas Krishna wishing all our viewers a very happy Republic Day. Now, the Archaeological Survey of India's report on the Gyanvapi premises shows images of sculptures, figures, statues, slabs, inscriptions and other objects that are unmistakably of Hindu origin. The images of deities of Lord Hanuman, shivlings, Yonipatta and inscription of Lord Ram in Devanagari. ASI in its survey has claimed that a large Hindu temple existed there before the construction of the mosque at the site. The report even details that parts of the temple were used in the construction of the mosque. ASI claims to have concluded the same based on the scientific survey. The study of architectural remains, exposed features and artifacts, inscriptions, art and sculptures present inside the premises. The survey report by ASI establishes the presence of a temple even before Aurangzeb's time. However, it would be imperative to see whether the same will hold water in a court of law or not. The Supreme Court's yet to hear the final arguments on allowing suits under the Places of Worship Act. Viewers, the Places of Worship Act guarantees religious character as it currently exists, or rather since 1947. It also is imperative to note that the Varanasi District Court has directed the ASI director to undertake a scientific investigation, survey or excavation at the site, excluding the areas of the ablution tank sealed by the Supreme Court last year.
You're watching the News Hour at 10, debate number 1 on Times Now, Super Prime Time.
For more on this, let's go across to our guest. Joining us with us is Ishkaran Bhandari, lawyer. Abhishek Sudhir, advocate, is with us. Abhishek, let me start with you first. The Hindu side, and you must have seen the press conference of Vishnu Jain yesterday. He says this is a big win for the Hindu side. There's a huge amount of evidence that has established the character of the place of worship and that it is indeed a Hindu one. Do you think that this is something that's going to be easy now or easier now for the Hindu side to establish in a court of law? Abhishek.
Well, I think it's established history that there was a temple there. I think the ASI findings confirm that. I think the real challenge for the Hindu side is actually to overcome the Place of Worship Act 1991. A single judge bench of the Allahabad High Court, Justice, I think Ranjan Agarwal, ruled that the Places of Worship Act was not applicable to this case because he said that the petitioners were seeking to determine the religious character of the premises, not in fact convert the religious character of the premises. So it's important to understand the court was saying that, well, we're trying to determine whether this was a temple or a mosque. So from that point of view, if they're merely seeking to determine the religious character, the ASI findings are a huge victory for them. But the Supreme Court is yet to rule conclusively on the validity of this judgment of the single judge bench of the Allahabad High Court. The Supreme Court has to rule on whether the Place of Worship Act is in fact not applicable. Are they merely seeking to determine the religious character or change the religious character? And now the question really, Vishnu, is what is the union government's stand? It's been a couple of years. The Supreme Court has repeatedly asked the union government for its stand, but the government has not made its stand clear. Without the government making its stand clear on this matter, I really don't see how the Supreme Court can rule on
this is Madhav, not Vishnu. Let me correct you there, but let me bring in Ishkaran on that point. Ishkaran, how easy or difficult is it going to be? How easy or difficult is it going to be to actually, deal with the Place of Worship Act? Because here's something that while there may have been judgments of the High Court in the past, Abhishek Sudhir and the Muslim side's contention would be that that is very much an act of law which will be perhaps difficult to sidestep.
I do not see any difficulty remaining in this case now. Firstly, even the naked eye could see that a mandir has been broken, and there is enough contemporary evidence to know that a mandir was broken, but still the court felt an ASI survey should be ordered because we need to prove everything scientifically and with evidence in a particular manner in the court. So that has come now. Whether the Places of Worship Act applies or not, there are two aspects to it. First, is the Places of Worship Act constitutional? The constitutional challenge is pending, and to my mind, it is not a constitutional act for two reasons. Reason number one, how can you carve out an exception only for Ram Mandir and not for other religious places and take away the rights of Hindus to approach court? The courts have time and again ruled that judicial review cannot be excluded. Who wins in the court, the Hindu side or Muslim side, in any case, is to be determined by court on evidence. But court not having the power to have, the Hindus not having the power, or any religion not having the right to approach court, that's the very basis of our constitution. And 70s onwards, the court have been unanimous that judicial review will not be excluded. You will not take away the right from any class of citizen to approach the court. So I am very, very certain that this Places of Worship Act will not stand the constitutional test. It's pending. So A, if that goes, the entire debate goes. Second aspect, in this case also, they moved a 711 application to say the Places of Worship Act applies. The court have ruled that it does not apply. The third aspect, what was the character in 1947? The ASI report says a mandir was broken and they have found deities in cellar S2 and they have found inscriptions and they have found the names of deities. So a lot of evidence has come. Once a mandir, always a mandir. They could also make an argument that in 47 also it was a mandir, but because of force, you were not allowing the mandir to operate. Because of force, you were not allowing people to worship. That would not mean that the mandir had ceased to exist. So there are multiple grounds to be taken, including, I think, the cleanest place that the Places of Worship Act is an unconstitutional law, or it does not apply to this case, which is already a judgment. Till the time Supreme Court comes to a different conclusion, that's the judgment which is operative. So that judgment is there. So I don't think so there should be any debate. But one last point, even under the courts have ruled, how can a mosque legally be made? Can you destroy a religious place? Can you make a mosque on a land not belonging to you? Those are also questions on which court has ruled. So they will also come into play once the ASI report is very clear that there was a mandir which was destroyed by Aurangzeb, and thereafter a subsequent existing structure was made on it.
Okay, let me bring in Abhishek on that. Now, Abhishek, a number of points that are being made by Ishkaran saying that there are several principles that the Supreme Court has to adjudicate on. So let's not rule out the possibility that they can adjudicate in the favor, and also talking about, and the Hindu side has repeatedly said that this is a place where Ma Shringar Gauri was being worshipped. And that happened even post 47. And therefore, when it comes to establishing the religious character of the place, they say that they have a very strong claim here.
Look, first of all, as far as the constitutionality of the Place of Worship Act, the Constitution bench in the Ayodhya case, it was a 5-judge bench, did not make any adverse remarks against the Place of Worship Act. They went, in fact, so far as to hold that the Place of Worship Act could even be considered to be a part of the basic structure of the Constitution. They basically remarked that this legislation was brought in the backdrop of the need for communal harmony. Nobody here is denying that temples have not been destroyed. Of course, several thousand temples have been destroyed. But today, if we were to relitigate all the temples that were destroyed, what is the social cost we're going to pay for that? The Place of Worship Act, the court had the opportunity to rule that the act was unconstitutional in the Ayodhya judgment. The 5-judge bench did not rule it to be unconstitutional. So if you ask me, the Place of Worship Act constitutional challenge to be heard, first of all, the union government should make it stand clear, or the union government, which has a clear majority, should repeal the Places of Worship Act. Clearly, they're not doing so, Vishnu. The Prime Minister is going to inaugurate a temple in a Muslim country, in the United Arab Emirates, very soon, right? When Muslim countries are allowing us to build temples in their countries, are we going to go around keep challenging and destroying mosques? Are we going to have another Babri Masjid on our hands? The costs are simply too many. If the Hindu side is saying that they want 24/7 access to Ma Shringar Gauri, I think the Muslim side should concede that. Right?
Well,
a
nobody is
workable
advocating,
compromise has to be arrived at. But
nobody is advocating anyone taking law into their own hands.
Litigation.
No, nobody is let me be very clear. Nobody is advising anyone taking law into their own hands.
When is it going to stop?
Least of all when it comes to a place of worship, and everything is going to happen as per the courts. Perhaps that's the only acceptable way forward. What happens, what the courts decide is another matter. But yes, Ishkaran wants to respond to. And Ishkaran, one point I want to say is that this very same High Court order has referred to the fact that any one place can have either a Hindu religious character or a Muslim religious character. It can't have a dual character. Do you see that view being expressed as perhaps a setback for the Hindu side's arguments?
Firstly, there is a lot of misinformation which is being spread because of the Ram Mandir judgment. Any act, Places of Worship Act, yes, the Supreme Court had certain observations on it, but the constitutionality of any act is either upheld or it is struck down when that act is specifically in challenge, when issues have been framed, when pleadings have been exchanged, when arguments have been read. So that has not happened. That is why the challenge is pending. If the Ram Mandir judgment had dealt with all that, then a new challenge would not be pending. The court would have decided the issue, either would have gone to a larger bench. So please let us be very clear, for the last time, Ram Mandir judgment did not uphold the Places of Worship Act for the simple reason it was not before challenged in the Ram Mandir case. There was an exception carved out for Ram Mandir. So let's be very clear on that. Now let's come to the second aspect, the social cost. Yes, what is the social cost? The social cost where a barbaric ruler wanted to create victory towers by breaking mandirs, and that has to be reclaimed and restored for any society to exist, for any civilization to exist. We are not Persia, where there are no Persians to claim their right, or Egypt or Mesopotamia. We are Bharat, where people are continuously worshipped and will claim their right. And there is a legal maxim: let justice be done though heavens may fall, even though no heavens will fall. The same bogey was done in Ram Mandir, that if a judgment comes, there will be large scale social costs, riot, law and order situation. Nothing happened. The same argument was made in Article 370. Nothing happened. The same argument is being made here. Nothing will happen. We cannot have a society and the courts of law hijacked by this implicit threat of social unrest or a law and order problem, and that will not fly, and that cannot be condoned. It's a simple case. Were mandirs destroyed? Were they not destroyed? If a mandir was destroyed, then every mandir so destroyed has to be restored, period.
One of the aspects also, Abhishek, is that, the Act, the judgment particularly says, the Allahabad High Court order, that the Act doesn't define religious character, only defines conversion and place of worship. What will be the religious character of the disputed place can only be arrived by the competent court after the evidences are led by the parties to the suit. So the Hindu side will obviously approach the court now, saying that this is enough evidence of the religious character.
Look, Madhav, that therein lies the conundrum. You're now going to have courts of law sitting in judgment on what constitutes the religious character of a particular premises or a particular place. Now, the Hindu side is saying that once a temple, always a temple. They are saying that once a Hindu god has been deified, that is always a temple. Nothing can ever change the religious character. They're also saying that a waqf was not created when the mosque, was built, essentially. So that is not a mosque. Now, are you going to sit in judgment on thousands of temples and thousands of mosques? And Vishnu, what is the end game here? That is my question. If the government of India comes out with a clear stand and says we are repealing the Place of Worship Act, let us, as Ishkaran Bhandari said, these temples were destroyed, now all these temples have to be built. Let the union government take a clear stand. Sorry. Like Ishkaran said, Madhav, that they said every mandir that's been destroyed, you have to rebuild that mandir. Now you have a Places of Worship Act that is essentially prohibiting that. So repeal the act.
So a lot of political parties also saying this. Ishkaran, today we have a situation where a lot of political parties are saying what Abhishek is saying, that if this is to happen, then you'll have to repeal the Places of Worship Act. Why doesn't the central government do that is a question that several of them are asking.
Of course, I am in the view that the central government should repeal the Places of Worship Act, but it can also be declared unconstitutional by the court. The citizens have the right to go to court, and it's under constitutional challenge. And the third aspect, would it apply in a given case or would it not apply? So there are three aspects. Central government can obviously repeal it. The Supreme Court can strike it down, or whether in a particular case it applies or not. In this case, because we are talking about a specific case, the courts have already ruled, at least as of now, it does not apply. The second aspect, if 1,000 temples were broken, then what is the big deal if 1,000 trial courts, you have 1,000 mandir cases going on, you have 10,000 property cases going on, you have 1 lakh property cases going on throughout India on various properties. So what is 1,000 or 2,000 or 3,000 or 10,000 or 40,000 cases more? It's not a big deal. The question is, if there is proof, and of course if there is proof that a mandir was destroyed, that case has to go ahead and a mandir has to be restored.
All right, we'll have to leave it there. Ishkaran Bhandari as well as Abhishek Sudhir. Clearly, of course, we don't have enough time for a debate as long and complex as this, but certainly in terms of what we can expect arguments to take place in front of a court of law, now that the ASI report is out with what they say is a huge amount of evidence that there was indeed a temple, it will be very interesting to see how this matter plays out in courts as well. Thanks so much for joining us this evening.